what courts are saying about that, which will be my focus in my hopefully relatively brief remarks, but also critically, how agencies are going about doing what they're doing, something I'll touch on at the end. Right now, the agencies, the administrative agencies and the government have a very ambitious regulatory agenda. You can love it, you can hate it, but I don't think there's any question that it is an ambitious agenda. And the FTC, where I work, might just be the best example of that. The rulemaking processes that we have initiated, the regulatory processes that we have initiated in the last year are relatively modest. And I'll just start by saying, and perhaps I'm not enough of a libertarian, I have supported at least the beginning of all of those processes. This is to do with imposter fraud and earnings claims and sketchy conduct by auto dealers, which too many of us are too familiar with. Personally, I'm not opposed to sensible regulation. On the consumer protection side, we have announced that we are going to make, or at least begin, a regulatory process concerning something called commercial surveillance, which is a definition that leaves itself somewhat open to different interpretations, but is something roughly like privacy, which of course is also a definition that leaves itself open to different interpretations. We are also looking at stuff on the FTC, and that's actually going to be the focus today. So just a bit of background for those of you who are not antitrust lawyers. The first US federal antitrust law, because there were state analogs before, was passed in 1890, and that's 132 years ago. And for 132 years of antitrust law in the United States, we have done it by lawsuits, private lawsuits filed in federal courts, and government agencies, the Department of Justice, and somewhat more recently, 1915, the Federal Trade Commission bringing cases, also state attorneys general. But the point is, it's a process of mediation of disputes and, on some level, truth finding through the court system, through an adversarial process. But in the 1960s, eager beaver lawyers at my agency, the Federal Trade Commission, looked at our statute with new glasses. I won't say what color they were, and they decided that also the statute conferred upon us regulatory authority to make rules. So not only could we bring cases, we could just say what the rules were. And we got, forgive a little bit of editorial here, some activist judges on the DC Circuit Court of Appeals to bless this theory in the early 70s. We made one rule. No one's ever heard of it. We never enforced it. It had to do with men's and boys' tailored clothing. You don't need to worry about it. We repealed the rule in the Clinton administration. But in July of last year, roughly a year ago today, the President of the United States issued an executive order concerning competition. And in that executive order, he declared, for purposes of the executive branch, that we have this power, that we can make competition rules, and that the power is vast and broad, and he encouraged us to use it. So we should make labor rules about non-compete agreements. We should make occupational licensing rules. We should make data collection and surveillance rules, like privacy rules. We should make rules about the right to repair. We should make pharmaceutical rules. We should make rules about digital marketplaces. The president took the position, as I think others do as well, that not only do we have this power, but that it is vast indeed. The chair has endorsed it, previously in academic writing and now in her capacity as the chair of the agency. Commissioner Slaughter, my other colleague, has also endorsed it. And one of the first things that the Democratic majority did when they came in, or when they had a majority over the agency last year, was there was a very, very vague statement where we said, this is what we believe the limits of our authority are regarding antitrust, and they promptly removed that statement. I hope that we replace it. I hope that it adds some more clarity, but right now, as far as some people are concerned, there are apparently no limits. So I don't think we have this power, but that's not what I want to talk about. What I want to talk about is where the agency is headed, and on some level, maybe analogically, where all the agencies are headed and where the courts are headed. because the courts are headed in the opposite direction. And I don't think that's controversial, and I don't think that's editorial, and I don't think you need to read a lot to figure it out. There are constitutional questions that courts are raising. There's a recent case involving the Securities and Exchange Commission in the Fifth Circuit Court of Appeals. There are two cases that are going to get answered by the Supreme Court about whether you can use district courts to attack the constitutionality of agency processes collaterally. So that's a little bit of jargon, and I apologize because Jennifer Kavanaugh said I should use less jargon. We have an agency process. We have a way of mediating disputes internally in the court that we have, but people want to go to federal court outside the process and attack it for constitutional infirmity. And if they succeed in this, it will make the process of doing these things harder to do because, as I mentioned a moment ago, courts have a lot of different views about whether the agency processes themselves are constitutional. There is also the suggestion, which we heard earlier, and which we'll talk about in a bit, that we will see a resuscitation of the non-delegation doctrine. The idea that in our Lockean form of government, you've got the executive, sorry, I did that out of order. You've got the legislature, you've got the executive, and you've got the judiciary. And there is a point at which the legislature can't just give the executive all or so much power. I think this actually applies to what I was talking about a moment ago with competition rulemaking, but that's not my focus here today. We did a podcast, so I'll just push some product for me and Corbin, where we talked a lot about that. What I want to talk about is the major questions doctrine, which is most recently exposited. I'm not even sure if that's a word, but most recently laid out in the West Virginia versus EPA case that came out of the court regarding the EPA's Clean Power Plan. Basically, if the delegation doctrine, the non-delegation doctrine is the idea that there is a point at which Congress can't just give away its legislative power, what the major questions doctrine says, broadly speaking, is that where an agency claims broad power or power not obviously recognizable from the statutory text, whether because it reads on something else or whether it's just vague or something like that, where there's a major question, a rule of vast economic significance or social significance, then there is essentially a presumption against it. So we saw that with the CDC's moratorium on evictions. We saw it with the vaccine mandate and OSHA, and again, most recently in the West Virginia case with the Clean Power Plan. Writing for the majority, I told you I'm a boring lawyer, so just bear with me. Chief Justice Roberts called out what he saw as a recurring problem: agencies asserting highly consequential power beyond what Congress could reasonably be understood to have granted. He worried that this is most likely to arise, I don't want to characterize him, you can read it for yourself, where you have ambiguous text or subtle text or modest text or vague text. Areas where creative agency lawyers, like the Eager Beaver lawyers at the FTC in the 1960s, could say, oh, that maybe could mean what I think it means, and I'll go make a big rule to change how we do society. Justice Gorsuch has a opinion as well, which is worth reading, about what he views as sort of the elements of this test, or the things at which we should look to get a sense of whether we're dealing with a major question. Everyone agrees that the ruling has a great deal of import. There will be a lot of dispute going forward about whether something is a major question. I'm going to say it right now. I don't think our earnings claim rule is a major question. So, right, I could be wrong, but we'll see. But the question isn't what's a major question. The question in my mind for the agencies is what is the takeaway from the case? And that is not hard to figure out. The takeaway from this case is when we are doing regulation, and when we are going big, and usually when agencies do regulation and they're going big, they tell you that. The President of the United States will tell you that. When a bureaucrat gets up and says we need to fundamentally restructure society, right? We need to change fundamentally the business model of modern American capitalism. Anytime they use the word capitalism, that's like a good hint that they're going big. These are clues that the major question doctrine may be in play, and they are also precisely that point at which the people who run the agencies, people like me on some level, should exercise a great deal more care. Because if we don't, I think we're going to have a negative reception in the courts. The rule that we've been talking about making at the agency under this alleged antitrust power is a rule concerning non-competes. And I have a bunch of stuff in here about why that probably rises to the test of a major question, but I don't want to get into that because I don't want to bore you guys too much, and these are better speakers. But I do think I want to end with a point that I think speaks directly to some of what we were hearing before about faith in agencies, faith in institutions more broadly. The agencies have grand ambitions, and the courts have something to say about grand ambitions and how they ought to be done under our constitutional scheme. But another thing that's going on these days at least some of the agencies, and I'll have an anecdote to support this, is that I think we're moving a little bit away from the expertise that is the nominal, or not the nominal, that is the justification for our structure, for our independence, for the bipartisanship that many of the boards and commissions in the US government have. There was a progressive vision. Right, the first era of this is under Wilson, and it really was of sort of pointy-headed experts digging in on the data and coming out with a version of the truth based on real research. And I feel like lately, we don't look a lot like that. So you can have a debate, you can have an argument about how well that fits within our constitutional scheme, right? And there's a whole history of Woodrow Wilson and his view of the Constitution, but I don't want to belabor that. The point I want to make, and I think this is exemplified in a report we did for Congress recently on whether AI is effective in combating certain online harms, including, by the way, the misinformation that we're describing today. I don't think we did a very good job. We managed to write a report on how companies use AI to combat online harms, and we didn't ask any companies that use AI to combat online harms. And I think that's a major methodological fail. What we did do is we went to those same reporters generating the clickbait. We went to some academics, ones who had a very particular view, and we came out with a report that basically said AI bad. That wasn't our charge from Congress, so that's a sort of movement from the institutional node that we are supposed to be, right? Jonathan was talking about nodes earlier in the context of expertise. But it also didn't do a very good job of giving a fair answer to the question. And I think as we talk on this panel, shut up in a moment, as we talk on this panel about what role the agencies ought to play vis-a-vis Congress, vis-a-vis the public, vis-a-vis lots of other things, vis-a-vis the courts, one place we definitely need to start is taking our job seriously. So maybe that's as good a place to stop as any. And thank you very much for having me.
Thank you so much, Commissioner. So speaker quality-wise, it's going to get worse before it gets better. I'm Corbin Barthold, Internet Policy Counsel at TechFreedom. Welcome. It's good to see you all. Again, title of the panel is Trust Institutional Design and the Future of the Administrative State. That is vast. So I'm going to just give some remarks that orient us around the work of this very impressive panel of speakers. One way to start doing that is to take two views, one at the ground level and one from high up. On the one hand, trust in government starts at the retail level. We have just heard about the Section 5 policy statement being repealed. That bipartisan statement made the promotion of consumer welfare the principal guide of the agency's antitrust policy. And as we just heard, the agency nixed that statement without receiving public input, without replacing it with anything else. I might have missed it, but I think Commissioner Phillips was modest enough not to mention that he issued a statement in objection to this that is very worth reading. The majority's decision, he wrote, reduces clarity in the application of the law and augurs an attempt to arrogate terrific regulatory power never intended by Congress to a handful of unelected individuals on the FTC. There's a lot of more good stuff in there. I recommend you go and actually just find it and read it. But in his statement, Commissioner Phillips urges clarity in the law. He defends democratic accountability in lawmaking. He stands up for transparent process. He champions the rudiments of good institutional design and trustworthy governance. He's fighting the good fight at close quarters. And if you don't have that, you don't have anything. That's the ground level. Meanwhile, though, we can view our current decline in trust in institutions from a 5,000-foot level. There are systematic, one might even say historical forces at play here. Consider a passage from another of our panelists, Stephen Teles, a professor of political science at Johns Hopkins and a senior fellow at the Niskanen Center. In his book, The Captured Economy, How the Powerful Enrich Themselves, Slow Down Growth, and Increase Inequality, written with Brink-Lindsey, Professor Teles says, quote, "Because of a combination of slowing growth and rising inequality, the prospect of upward mobility and a brighter future is now receding out of reach for more and more of our fellow citizens. As a result, American democracy is weakening as well, as pessimism and frustration have smashed public trust in established institutions and opened the path to power for populist demagoguery." From this perspective, restoring trust in institutions, including the administrative state, is a deep structural problem. It is not something we are going to fix with a new law or a court decision, or even by cloning Noah Phillips. So there's two lenses to look at the issue right there. Our other panelists too have thought deeply about issues surrounding state capacity and trust and all the rest. Let me touch briefly on some of their insights as well. Michael Munger is a professor of political science at Duke University. Professor Munger has worried about whether our system of governance has a natural tendency to slide toward crony capitalism. I recommend his essay, The Road to Crony Capitalism, co-authored with Mario Villarreal Diaz. Encouraging corporate dependence on the state and collecting revenues from running artificial rent-seeking contests, Professor Munger writes, are primary money-making enterprises of successful politicians. As this passage suggests, Professor Munger is well-versed in public choice theory, among many other things. So I look forward to hearing his thoughts on whether there's a way out of the cycle of bad incentives, feeding bad behavior, feeding bad incentives that we see in much of our governance system today. Last but not least, Larry Downs has held positions at Stanford, UC Berkeley, and Georgetown, among other places. He's the author of several books, including most recently, Pivot to the Future, Discovering Value and Creating Growth in a Disrupted World, co-authored with Omar Abash and Paul Nunez. Professor Downs has thought a lot about technological disruption and about whether the government is capable of keeping up with accelerating change. Take his article, A Measured Approach to Regulating Fast-Changing Tech, one of many he has published in the Harvard Business Review. Is the world changing too fast, he asks there. And if so, are governments capable of regulating the pace and trajectory of disruption? I look forward to hearing his latest insights on those questions. Finally, if I haven't already set out enough threads for our conversation, as the commissioner laid out, West Virginia versus EPA is a monumental decision, and I will hope to be tying us back to that several times. So I'm thrilled to be moderating this panel. I'm going to sit down now. Welcome to all of you. Thank you. What I plan to do is start with a round robin. I wanted to make it so no one had to prepare remarks if they didn't want to. So I have questions that I will pepper people with, although they should feel free to maybe just sidestep it and go to opening remarks if they want. And then we will go to questions for the group. So first off, we have Professor Teles. And I have to admit, I'm a giant Stephen Teles fanboy. I'm so glad he came on. So I had questions about like the whole scope of his corpus of work, but we're going to put those aside. Maybe we'll circle back to them because he has very thoughtful remarks about the topics we've just laid out. So please go ahead.
Yeah, so I should say if you're a fanboy of me, that may raise lifestyle questions that you may want to talk to a specialist.
Oh, it certainly does.
About. And I should also say, through the grace of a loving God, I'm not a lawyer. So my comments, I think, will reflect that and may, in fact, even reflect a kind of legal nihilism that's partially a professional feature of being a political scientist as opposed to a lawyer. But as I say, your mileage may vary. So my basic, the thing I'm here to say in my sermon today is that the pattern of broad aspirational legislation, vague legislation that provides authority for far-reaching administrative policymaking is in trouble. And West Virginia versus EPA, I think, is just the first toe in the water. Orwell famously said that probably the Battle of Waterloo was won on the playing fields of Eton, while the battle over the administrative state is currently being won on the playing fields of the Federalist Society. And it's best to say, to understand this attack on the administrative state, not in terms of doctrine, and this is where I'm very much not a lawyer, right? I think if you try and understand this in terms of people earnestly seeking the right legal rule based on norms internal to the legal profession, much of it won't make any sense. And I don't say that in a critical way, because I'm actually mostly sympathetic with West Virginia versus EPA. But I think it's best understood in terms of how liberals have learned to leverage their power resources and how conservatives have learned to try to block that leverage, right? That is, I think if you think about this mainly in terms of institutional power seeking and counter strategies against institutional power seeking, all of it makes much more sense than if you just think of it as lawyers at work. The law, I'm going to argue, is just the means and the post hoc rationalization for a different project. So how should we understand West Virginia versus EPA and the larger legal attack on the administrative state as a strategy for disarming Republicans' opponents? We should understand that, in fact, in response to this, and not just this, but all the cases that will be coming ahead of West Virginia versus EPA, Democrats have almost no tools to do anything about it, right? And this is where, again, I'm a Democrat. I look at people who, and I wrote a piece in the New York Times, I guess it's about like a year ago, that more or less said that the Democrats actually have nothing they can do about the current composition of the Supreme Court or the direction of its jurisprudence. They're not going to successfully court pack or jurisdiction strip in response to any of this, at least if the court mostly sticks to proceduralism rather than going full Commerce Clause and denying the federal government, as opposed to regulatory agencies more narrowly, the authority to govern. Right. That is, I think if they went that far, that would in fact get Democrats willing to get up on their hind legs and actually start thinking of some of these more extreme measures. Right. So the question is, if Democrats actually can't do anything about the line of cases that'll be coming out of West Virginia versus EPA, then what happens? Right. And so I would argue that much of American liberalism is an adaptation to a particular way of doing policymaking, passing broad, aspirational, vague legislation, and then constructing it incrementally through administrative agencies, charitable foundations, interest groups, litigation, professions, and the division of firms and organizations. In other words, the structure of what liberalism is ideologically, strategically, and organizationally has co-evolved with the structure of the state that was built mainly in the 60s and 70s. Democrats got good at squeezing everything they could out of the relatively rare times that they could pass legislation. And that legislation was mostly designed to provide a platform for this decentralized, expert-driven policymaking. Well, West Virginia versus EPA shows that the structure of the state that helps structure what we understand to be liberalism is changing. And as I suggested before, that means tightening up constitutional rules precisely where liberals are strongest. And again, this is where I think understanding this in terms of a counter strategy against exercises of liberal power makes the most sense. And so liberals, my friends, are mainly terrified by this turn in the court. And I'd like to suggest that it might not be bad, that it might be bad for existing liberal organizations, but in the long term, it might be good for liberalism. First, my instinct is that this class of decision and decisions that'll come after it will lead to irrepressible momentum for scrapping the filibuster, either in toto or for legislation designed to respond to court demand for a clear statement on a major case, right? Again, which is not comparatively unusual, right? There are courts in the world that do something like this and have special access to the legislature in these cases. I think that's mainly because if the court is asking for clear statements on major questions, Congress has to be more capable of making clear statements on major questions, right? And obviously the filibuster is a major institutional obstacle to them doing so, right? So one way to think about this is a world with a Congress with a filibuster and a world with a kind of anything goes congressional delegation go together, a world with strict rules on congressional delegation and a rule with no filibuster go together. But having the other mix doesn't make sense, right? So second, I think that at least when Democrats are in charge, the line of cases that are going to come out of West Virginia versus EPA is going to create considerable pressure to build up the capacity of Congress. If the court is going to block administrative agencies from doing policymaking, Congress is going to have to figure out how to do what it's gotten bad at doing. And they'll have to make large changes in their operation to do so. So in terms of Congress, the change in the behavior of the court is happening in a period of acute polarization of the parties. And I think it's shaping, its output is in part shaped by that fact. This has determined how Congress works. In particular, it's led to a Congress that has centralized power in party leaders and consequently reduced the likelihood of cross-party coalitions by preventing issues off the axis of party competition from getting on the agenda. And I think there's a likelihood, as I argued in a paper in National Affairs with Rob Saldin called The Futurist Faction, that we're going to see more durably factionalized parties in the future, and with them more demand for cross-party legislation, right? So the unified homogenous parties we've gotten used to are going to start looking more like the parties of the 1950s and before, where they were basically loose confederations of ideological or regional groups, right? And political science theory mostly suggests that if we have a demand for this kind of cross-party legislation, along with the work burden of having to do more legislation because what the courts are making agencies do, will generate institutional decentralization in the form of stronger committees, right? So again, once you get this perturbation in the system that's generated by what the court is doing, it's going to have a lot of these other systemic effects, right? And so Congress might get better at legislating, but in a way that's different than the quasi-parliamentary way we've gotten used to. When you combine that with a Congress with more capacity and stripped of its ability to leverage regulatory agencies for change, you might actually see a movement toward our legislature actually legislating. The second regime level change that's going to gradually filter out of these changes in the court is a change in liberalism itself. And I suggested before, modern liberalism in the administrative state co-evolved. Having large mobilized followings was less important than having access to resources and expertise that would allow you to squeeze influence out of insulated venues of governance. Well, those insulated venues of governments are gradually being either dismantled or being cabined. And if liberals can't get change through those kinds of mechanisms, my prediction is the organizations designed to do so and that have co-evolved with that state in that way will gradually desiccate. And organizations designed to generate the social power to do big, transparent, transformative things, which also means tearing up legacy policies and replacing them, which gets us to the collegiocracy point, will gradually replace them. Liberalism will have to go back to being more mobilizing, more focused on issues that attract a large base of ordinary Americans, and less focused on its current narrower class basis, what Thomas Piketty has called Brahmin left. They'll also need to do more strange bedfellows, opportunistic legislating, not unlike how Ralph Nader helped push deregulation in the 1970s. So in conclusion, I think that if those of us who think of themselves as liberals, even those like me who are barely in the category, take note of the opportunities that are available in the world that is being partially created by the court, but also partially by other tectonic changes, we can actually make policy to deal with problems like climate change and inequality, but the instinct to try and preserve the status quo, what we've gotten used to as understanding as liberalism, is strong. But I think a liberalism that co-evolved with a new set of institutional arrangements focused on Congress would be better in a variety of ways. You'd have a liberalism that was more popular, more mobilizing, and that generated policy that was more broadly recognized and legitimated. And a liberalism like that might also create a better conservatism in response, one that actually had to generate policies to compete with a more popular legislative-oriented liberalism as opposed to accusing them, often rightly, of stealing bases through administrative state sleight of hand. Thank you.
Thank you so much, Professor. I know you don't call it a prediction. It is a scenario that you lay out whereby there might be more cross-party work, which I really enjoy. I encourage people to go and read his work on that. Certainly, if you get rid of the filibuster, it's better if we have cross-party work than if we have a 51-49 bloodbath where red and blue try to bludgeon each other and then whiplash. So I don't know if you call it optimism, but I'm glad somebody is looking at a potentially better future. Professor Munger, please go ahead. If you have opening remarks or reactions, you can just do those. But the one thought I maybe would throw at you to begin with is in a lot of your work, you focus on public choice and sort of the corrosive effect of rent seeking. We seem to have a Supreme Court, and it's not just in West Virginia versus EPA, you know, SEWA law comes to mind. There are other instances that has an interest in rebuilding constitutional boundaries. So how much solace should we take in that? I mean, is that rearranging deck chairs on the Titanic, or does that hearten you?
Well, that's a really hard question. Let me take a shot. First, let me apologize for feeling really old. I knew Baron Joka when he was a freshman at Duke nearly 25 years ago. And my first job after I got out of graduate school was at the US Federal Trade Commission. I believe Commissioner Phillips was 6 in 1984 when I started. So as I am, as you, most of your generation would say, old AF. So a lot of my work has been on the problem of industrial plans, and capitalist systems have a baseline industrial plan that is based on the signals that are given to us for particular kinds of prices called profits and loss. And the question is, under what circumstances can government agencies using expertise either fiddle at the margins or direct that immediately towards something better? And the people on my side, as George Will famously said, the Cold War is over, the University of Chicago won. That kind of triumphalism, I think, was at best misplaced and perhaps in retrospect simply incorrect. But the question is, we now have a new set of industries that are ill-suited to the existing regulatory structure. And the reason I think that that's true, as I've argued in a couple of books, is that we have systems that now, rather than being based on firms, are based on what you might call platforms. And I can't go into the details, but basically a platform is something that solves problems of triangulation, transfer, and trust. That is, one-on-one markets, people are able to find each other in a platform or context. So Uber doesn't sell taxi rides. They find someone who has a car in a few minutes and they match it with someone who needs a ride. So the problem of triangulation is solved by individuals who already could engage in a mutually beneficial transaction, but without the help, without this context, without this platform, they can't do it. The second is transfer. You have to be able to deliver the service and you have to make the payment. The last is trust, which is part of the title of this session. And the problem with trust is that I need to have some more or less seamless assurance that you will carry out your promise and that I will carry out mine. And we can't have adjudication of this in the courts. It has to happen just automatically. And so the hard thing is the dog that doesn't bark. Much of regulatory structure is designed to settle disputes. But if this is working well, then bureaucrats don't have a job. I've often worked with the Law and Economics Center at George Mason, and when I give federal judges, because we train federal judges, well, forgive me, we expose federal judges to economics. Whether they're trained, I don't know, but we expose them to economic propositions, and they'll often say, well, that's not the way I run my courtroom. That's the point. I'd like for you to be out of a job. So if transactions costs are low enough, you'll be out of a job. The question is, well, let me give an example of this that comes from a person I admire very much, Daphne Keller, who's the head of the Stanford program on platform regulation. She says often the temptation for platforms that are successful, because they become giants, When these things become giants, it's very tempting to say we should apply the antitrust law. And so Daphne Keller raises the following example. There's this platform that has 35 million daily unique users, and they can decide who gets to publish on that platform. They can remove anything that they disagree with. In fact, they can bar you even from reading it. So therefore, we should break up the New York Times, because that's the platform that she's describing. It is the nature of a platform that will have a monopoly within the platform that it has created, because it satisfies those three criteria. So the question is a system that was based on competitive markets suitable to be able to solve this problem? That is, can we use antitrust? And I've argued over and over again that the answer is no. On the other hand, these wild techno-libertarians like Barron, I don't know where he gets this, need to recognize, actually when I want to agree with him, that the problem is actually epistemic atomism. That what we need is institutions that can grow up in a setting where the visible hand of regulation is operating invisibly behind the invisible hand of the market. So this is not an anarchist problem. There's a visible hand of regulation. The question is Section 230 up to this task? So I want to raise just an analogy and then I'll quit. But the analogy is to what happened between 1480 and 1550 with the invention of the printing press. Because this is not about what happened in the 1960s with regard to television. Between 1480 and 1550, something fundamental changed about the ability to provide information, and I'm putting that in quotes because it may not be true, to the mass public, at least that portion of the mass public that could read or that someone could read aloud to them. The three things that mattered for the creation of institutions in that setting, and it still matters today, are publication, curation, and verification. Publication means how costly is it to put this before the public? When books were really expensive, probably you're only going to put things that are true or that you're going to be able to sell a lot of copies over a long period of time because the setup costs were great. Between 1480 and 1550, they started creating something that we now call pamphlets. And pamphlets were Twitter. Pamphlets were Twitter. It was anonymous, it was extremely cheap, and mostly you would look at stuff that said, there's this evil person that lives in the moon, pictures inside. And when you look at it, you think, damn, that's really interesting. I'd like to know more about that. I know it's not true, but gosh, it's interesting. So if publication is free, you have a real problem. Curation is what's important. And the discovery of what's important is something that we need institutions to do, because otherwise what will be substituted for that is clickbait. The third thing is verification, and that is what is true. If you have a setting where institutions have not arisen to solve the problems of publication and curation, verification is almost impossible to solve. So the question is, are we better off using some kind of regulatory framework under the existing flawed system that's mostly based on antitrust? We're going to try to break up for size, where size is just a consequence of being a successful platform and matching what people want with what they're trying to, what people want with what they're trying to get. Or is there some alternative way to think about what regulation might do? And I actually have more and more come to the conclusion that there really is a problem. It's not a problem that antitrust can solve, but it's more the kind of problem that Foucault talked about with panopticon and the kind of surveillance capitalism that is legitimately likely to be a concern to the extent that it not grows in size in a particular domain, but that it connects across different domains. So the analogy that I would make to the regulation of the financial industry is the problem might not be that a bank is too big. The problem is Glass-Steagall kind of regulation, where you can't be both a casino and a grocery store. So the question is, can you be both a Facebook and a TikTok and a Google? If those things all can share information, there may be threats both to capitalism and democracy, where new institutions that grow up under a system of profit and loss under Section 230 are not capable of solving the problem. Thank you.
Thank you so much, Professor Munger. I am going to try and keep us on schedule by doing some more in-flight saving. Commissioner Phillips, can I just plug our podcast and say everybody should check out our tech policy podcast? And I'm plugging it again and saying, so we've heard from you. I'm going to skip down to Larry Downs if we can and get back to you. So much interesting stuff in Professor Munger's talk, and I'm going to lift out a little piece of it that we're just talking about new institutions in the private sector, platforms, and we have government institutions that were directed at, say, New Deal era issues. So we have government agencies that were founded to address problems from the far side of the previous century, now looking at drones or satellites. So at a very high level, I'd be curious for your thoughts, and feel free to just give your opening remarks and ignore me. But what I'm curious to hear about is are those institutions up to the task of keeping up with technological change?
Right. Okay. So thank you, Corbin, and thanks to TechFreedom for having me. I haven't been back to DC for a very long time, so it's nice to come during the good weather. So I mean, where I come from, I should say, so in 1998, I coined something called the Law of Disruption. And it was essentially a pseudoscientific. Gordon Krovitz wrote a very nice review of that book in the Wall Street Journal, but I don't think NewsGuard would actually give me a very good score in terms of the background science of it. But what we said in the book was that the nature of technological change was accelerating. The nature of all other institutional change was incremental. And so in the first book, we were looking at, the sort of impact on business of technology that was changing faster than businesses could change. And that really was the work I did for the next decade. It came back in 2010 and said, well, okay, let's look at another institution. Let's look at government. How does it respond when technological change accelerates? And again, government is incremental, even more incremental than industry. So what happens in the sort of accident-prone intersection of those two? Just as a side now, that what I've been working on for the last year is now looking at it at the individual level. So what happens to your career? What happens to the labor market? Again, when you don't change as fast as the technology does, and you're going to fall further and further behind. I cannot find a publisher for this book. The field is very crowded, most of it by Instagram influencers. Who have never worked a day in their lives, but that's another matter altogether. So, well, back to the government. So what we found was, of course, the problem is even more difficult for government than it is for industry. Government is a sort of a trailing indicator in general, if you will. Industry changes; it's often very chaotic and not very pretty and very Schumpeterian, and then government is behind that. And it's designed to be behind that. This is not a criticism of the Constitution. It's not a criticism of any agency. But yes, as a general rule, it's going to be more difficult for government to keep up than it is for industry, and industry doesn't keep up very well either.
Do you see any larger systemic message from, say, I look at the FAA putting requirements on SpaceX if you want to launch your Super Heavy out of Boca Chica, so there's some environmental requirements, and those seem reasonable enough. You're shooting a rocket in the air. Let's see what that does. But then they had to fix a historical monument and do like a study of the Mexican-American War there, and it was one of the best sort of rent-seeking examples I'd ever seen. And I did wonder, okay, is this just a run-of-the-mill rent-seeking instance that like there's no significance here? Or is this like a larger message of the lack of state capacity, where it's like, if you can't, we don't know how these rockets work. What are we doing? Well, make them do a study of the Mexican-American War. Like, do you see anything larger in that kind of thing?
Listen, I'm from Chicago. All politics is local. It's funny, but it doesn't bother me as much as I think you asked that question, and it's very interesting because I started thinking about different agencies. And the real answer is that some institutions are better designed, they're better equipped, they have better jurisdiction to respond. None of them, are going to be instantaneous, but like, for example, given Commissioner Phillips is here, the FTC, essentially it's an agency of general jurisdiction. Its charter is to look at competition and market behavior. And that has meant that it's not locked into a particular industry. It's not locked into a particular technology. It's made it more flexible, which turns out, again, when you're having accelerating change, it's a good thing. You also have agencies like the Federal Communications Commission, that don't necessarily have that flexibility, but they've got a lot more experience with disruption than agencies like the FAA, whose principal technology hasn't changed since the FAA was created. So you've got, the FCC has gone through, cable and satellite and cellular and the internet and streaming. And, they may not be as quick as we like or as apolitical as we'd like, but at least they know what disruption looks like when it happens. And at least, they're not as surprised. Then you've got, you mentioned the FAA and drones. They've never seen not only they haven't seen drones, they haven't seen a technological disruption before or in a very long time. So then you think about, let's say, the IRS and the SEC trying to deal with crypto. They don't even know that that's in their world partly because of, public choice issues. They're used to thinking of their client as the industry that they've been regulating all along. And so if that's not the one that's doing the disrupting, they're not going to see it, or they're not going to see it right away. The Department of Transportation, autonomous vehicles. Again, it's not their usual client. So again, they're not going to see it right away. And the Department of Education, and thinking about, what happened during the pandemic, I was reminded, I had the good fortune years ago to work with Alan Kay, a sort of pioneering computer scientist from Xerox PARC and elsewhere, who was very focused on education and use of technology to improve education. And Alan used to say the last technological innovation that happened in education was the book, and they still haven't responded. That's, well, maybe it's not an exaggeration. So the problem is not the sort of structure of agencies or structure of institutions. I think the problem is really some agencies have more experience, some agencies have more flexibility, and some agencies have more authority. If you don't see the disruption coming because the industry you're regulating doesn't see the disruption coming, then you're always going to be a lagging indicator. And the more of that happens, the less successful your response is going to be.
Very nuanced. I appreciate that. Well, I'm going to open it up to the group now. And the question I'm going to start with, though, Larry clerked for Richard Posner, so he's going to get the right of first crack at this one because it starts with a quote from Richard Posner from 2005, a former Seventh Circuit judge, very prominent, as I'm sure you all know. And I quote, "In the face of formidable challenges to the safety of the nation, of which we have had an abundance of recent warning signs, the latest being the threat of a lethal flu epidemic with which we apparently are not prepared to cope, the government has entangled itself in contentious, emotional, and it seems to me distinctly secondary issues. Matters such as abortion, fertility treatments, homosexual rights, affirmative action, religious displays on public property, capital punishment, voluntary euthanasia, and the proper treatment of people in vegetative states are not appropriate issues to entangle the federal judiciary or the other branches of the federal government. They are not worthy problems for national government in a federal system." So again, that's in 2005. And so the list in some ways is, I suppose, a bit dated. In other ways, maybe it's prescient. But what I see there is this kernel of getting the federal government embroiled in culture wars is not what the federal government is for. And to the extent it does that, it is not going to function. And I think a side issue there is if we are all, I am sitting here at least thinking, I'd like the constitutional structure to work better. Schoolhouse rock, where Congress passes the law and the executive administers it and so on. But we are so embroiled in culture wars that say that kind of thing codes as right wing because it lets the EPA do less in a recent major questions decision, for instance. It's all kind of for naught. So Larry, do you think do you think Judge Posner's assessment was accurate? And if it was, I mean, is there any way to extract us from that? Or is it sort of people want the federal government to fight the culture war, so that's what it's going to do? So a lot of wasted breath.
Okay, so this will be really short. So my short answer to your question is what Posner said still accurate. The short answer, yes. The long answer, yes. Slightly longer answer, bring back the Office of Technology Assessment. This was the agency that advised Congress in a nonpartisan, expert-driven way on new technologies. It was eliminated during the contract with America. I can't remember what year that would be. I sort of get lost there.
96.
95.
Mid-90s?
And there's been periodic, discussions about bringing it back, just as a sort of simple, concrete recommendation. That would help. Now, does it get Congress out of its current, stalemates and so on? No, but at least it's a start.
Please. Yeah,
At
please.
that, just on the Posner line, because again, as a political scientist, I'm generally less likely to have a normative theory that this is like inappropriate or it's bad, but I can give you an account of why it is, right? And I think why it is that when you have a system in which party leaders have dominant control over the agenda, right? What they're going to do is use that agenda control to keep things onto the agenda on which the parties are sharply divided and there's very little overlap. And they're generally not going to want issues to get on the agenda where the parties are divided or where you have strange bedfellows coalitions because they don't like splitting their own coalition, right? And so the thing that characterizes all the issues on Posner's list, right, is there really good, clean splits between the parties. So it's not surprised that the party leaders want those things on, right? And so again, part of my argument in futurist action and the part where I gave you the little like 10-second version of that is a world in which the parties are more internally divided, in which leaders have less power and therefore have less agenda power, is one in which those other issues that Posner is suggesting have more of an opportunity to get on the agenda because they have more opportunistic or strange bedfellows coalitions. But you have to get to that world. You have to get to that world where you've got that internal division that then makes parts of each party want to work with somebody in the other party and use whatever leverage they have to force their leaders to get weaker in terms of their agenda control.
So one kind of maybe response to Posner a little, but also a question for you as the political scientist, which I am not. And I need to stick to my node. So before I was on the FTC, I spent 7 years on Capitol Hill. And one thing I didn't hear a lot was lamenting at how strong party leaders were. Because the trend seemed to be over time that actually like money flew out and attention flew out and leaders were weaker than they used to be. It's true, right? Like Lyndon Johnson, right? The strength of the majority leader on the Senate floor to fill the tree and all of that. Like definitely there was a growth in leadership power, but I feel like a lot of people used to talk, and I think still do talk about how now leadership actually has far less control. And so you see power more dispersed within parties, and people view that as inhibiting the ability to get things done. I don't have a view, but I'm curious what your thought on that is. Can I just add one comment though? To the Posner,
Talk to him, he's in charge of the.
he's in charge. So let me make one humble proposition. And it doesn't solve all the problems, but I do think it may help us both deal with our like.
Are you circling back to the cloning you idea?
No, that's a very bad idea. It speaks to the major questions thing in terms of how courts look at what agencies do. But I think, Posner is focused on like cultural versus other issues and maybe even like a constitutional view of like what the government ought not to do. I mean, that's a kind of legal question and it's a political theory question, but I think one thing that we're not doing so much of late, especially in Congress, and this does speak to the major questions issue, we're not agreeing on what we're solving. Like, forget the solution, forget the unintended consequences of the proposed solution, take speech regulation, which they're all going to talk about later. You will hear members of Congress, one will say, everything is wrong because there's all this bad speech. And the other member will say, everything is wrong because my political allies are being censored. And then they will both say, we need to do X to section 230. Mathematically, this can't be right. Right? They know they want to cudgel, and maybe they know who the bad guys are, like rein in big tech. How? To do what? And I just think like more time on where we want to go, forget how we want to get there, actually would solve not all, not even most, but some of our inability to figure out how to get there.
Can I ricochet that actually to Professor Munger really quickly? So are we better off with just a dysfunctional Congress that can't do anything, that like they're stuck pushing through the door in like opposite directions because it's that incoherent? I mean, are we in kind of the Pareto optimal dysfunction?
No, I'm also a political scientist for a very long time also. That's my recurrent theme, I guess, about being old. I'm old enough to remember when the committee system and the committee staffs were actually expertise that were deferred to, and where expertise carried some weight. So I believe Professor Teles is right that there's a concentration of agenda control of a particular kind in the party leaders. That is, they can prevent legislation from coming to the floor. The decline of the expertise in committees and the emphasis on getting legislation passed that was of appeal to voters has been a catastrophe. I have heard a number of Republican leaders actually talk about how great Marjorie Taylor Greene is, because since she has lost all her committee assignments, she can focus entirely on fundraising. How awesome. Well, the object of the Congress is not fundraising, unless it is, and I'm wrong. The object of the Congress is the deliberative process that leads to legislation to solve some pressing problems. And so the difficulty that I see is that the individual objectives of members are actually being pretty well solved by much of what we see now. But the institutional collapse of the system of expertise and committee decentralization, where it is now centralized in the inept leadership of one or by a small group of party leaders whose objective is to try and do a little bit better in the next election, is a catastrophe. So I'm not a fan of gridlock. I'm a fan of deliberation.
Now, I think Commissioner Phillips had directed at Professor Teles, and I know you have to go pretty soon, so please take the floor.
Yeah, so I'm trying to remember, because now I was thinking about like answering.
His is more interesting.
Well, so
Polite chaos is my goal.
Yeah, so let me just say just one thing on this, and I'll see if in the process I remember what Noah said. I'm totally in agreement with Mike, right? And again, I think the decline of committees is, again, you had your colleague John Aldrich, right? Who is for me is the great saint. I should have a big picture of him, right? And he developed a theory called that basically said that parties are responsive, and the organization of Congress is responsive to the degree of homogeneity in the parties, right? So the more homogeneous the parties are, the weaker committees are going to be, and the more party leaders are going to get power, right? Because for basically principal agent theory reasons, right? That is, when they're homogeneous, the party leader is unlikely to be very far from your ideal point, right? Did I do okay, Professor? Okay, so in that sense, the strong party leaders we have now are the equilibrium response to the fact that our parties have become so homogenous. And therefore, if you want to get to where Mike wants to get, which is weakening central party leaders and allowing for more decentralized determination of the agenda and more decentralized deliberation on alternatives, the only way to get there is through less homogeneous parties, right? And so in Futurist Faction, we basically suggest we already see the beginnings of that process, right? You think about the Justice Dems, right? They're creating a faction inside of the Democratic Party that is separate in lots of different institutional ways from the rest of the party. I think that the equilibrium response is for those who are on the other end of the party to have to organize just as determinatively and institutionally. The more that happens and the more they're seeing parallel factions in the other party, the less those members are going to be willing to defer to their party leaders and transfer power, and the more they're going to want a more open agenda, right? They're going to want to have more different ways to put together coalitions, and they're going to want to decentralize power down to the institutions in which those deals can be made, which are congressional committees, right? And that, so again, if I have an optimistic story, it's that we know sort of theoretically how you get out of a problem like this, right? Whether you can actually get out of that problem is a separate question.
Commissioner Phillips, could you talk about the possibility that it would help to make your job harder? Is Congress doing enough oversight of your agency and I don't mean that in the nitty gritty view. I guess I should say agencies writ large. Should the purse strings be tighter? Should they be looked at more closely? Or are we doing okay on that front?
I mean, we do a lot fewer hearings in the last year and a half than we used to do. So there's a sense in which if you had to get like a metric for oversight, hearings are probably a good proxy, right? Because in a hearing, you're calling the people in and you're asking them questions and the members are getting the briefing on what's going on at the agency. And that's how oversight kind of functions. Because in part I spent time on Capitol Hill, I like to think of myself as, forgive me, but an Article 1 guy. So yeah, I think more oversight is good. It's not always easy, right? You have to get up and you're under oath and answer questions. It can be uncomfortable, but I do think fundamentally, in terms of the transparency that you were talking about before, that's critical. And it's critical that answers to questions come in a scripted way. Right? Surprise is good for public awareness of what's happening. Different kinds of questions are good. It's especially great, I would humbly propose it, an agency like mine, where because you have commissioners from different parties and with different views, you get different answers. Right? And that, I think, even though you're not going to get one coherent answer, that helps everyone get to some version of the truth, which I think is better reflective of it than just from one voice.
Can I get
Please.
I'm going to have to go in just like 3 minutes.
Absolutely.
I just rememred Noah's question. So I just now I can actually
Go for it. Absolutely.
Which is the point about party weakness. And again, as they say in things, I refer you back to my previous answer. One way to think of it, if you think about parties in Congress, the way that I've just been describing and that I draw on Aldrich and other political scientists, that we think about party leaders, oddly enough, in that model, as agents rather than principals, right? That is, the party members are the principal, right? And they choose an agent in the form of a leader to do their bidding, right? And so when those members are homogenous, right, they'll choose an agent because they think the agent would do what they would do, right? Okay, so that's great. So how does that then explain why party leaders seem weak, right? Is that they're only strong. They can only do the things when they're writing legislation in their offices that they believe their members, their principal, want them to do, right? And part of what they want what their members are telling them they want them to do is to protect them from issues that aren't on the axis of party competition, right? They're saying, what we want you to do is to keep all that stuff off, right? Now, if the members said, actually, what I really want to do is I got all these weird coalitions in my mind for all these issues that are not on our axis, right? And therefore, I need those members in the other party to do it, right? Then they would take some of that agenda setting power away from their leaders, right? Now, and again, when you think about the leaders who are powerful in days yore, right, which is what you were referring to, right? Those were leaders actually in a very heterogeneous set of parties, right? So LBJ, people thought was a genius because he knew where all the levers to put together multiple different coalitions were, right? Whereas our leaders are now people who literally only know how to do one thing, right? They know how to pass legislation under the conditions in which all their members are agreement, and they can just shove something through in a single piece of legislation, right? So that's the paradox of congressional leadership weakness that's also kind of strengthened.
I think I'm launching off that point and saying this, that, there's like 12 people who just kind of want, thank you so much, Professor, who want the system to work. I think a lot of them are at this table in the sense of proper process and running things sort of in accord with the separation of powers and all that good stuff. There are a lot of people who in our tribal society, it's coded. It's red team, it's blue team. So you have things like, and it's too bad Professor Teles just left because he could have sort of shot back at me at West Virginia versus EPA, maybe not being the civic-minded decision that I'm going to describe it as. It's shoring up those proper boundaries, and therefore I applaud it, even though it leaves many, many open questions. And that's a game I'm playing Commissioner Phillips is not just playing it as a game, like he's on the ground, as I said, doing that. Meanwhile, a lot of people, all they're going to hear about that decision is bad for the environment. Boo, that's the level here. Does it help me today? The filibuster is another great example of how cynical people can be of, I favor getting rid of this filibuster depending on what it'll do for me today, not looking down the line. So Commissioner Phillips, it's a very hard question. You're clearly doing the good work on the retail level, as I've been describing. But how do we make people value that? How do you convince people that that's the right game to be playing and that, we shouldn't all just be results oriented?
How do I convince people to like what I'm doing? The jury is very out.
I don't know that I have the answer to that question. It's a very hard question, and I could move on.
Can I come back to Congress for a little?
Please.
So a friend texted me last night. He used to be the chief of staff to Gary Peters, the senator from Michigan. And I used to be chief counsel to John Cornyn, the other senator from Texas. And he texted me the statistics. The two of them were 1 and 2 for lead sponsorship of bills that got signed into law thus far this Congress. When I worked for Senator Cornyn, he spent a lot of time legislating. I think for a number of those years, he was the most prolific legislator. He co-authored more bills. Now, some of them were small bills. You heard about that earlier. But I do think, a lot of this conversation has been Congress is broken, but secretly Congress does stuff. I do think we don't pay enough attention. We don't give enough credence to the people who do the sort of less politically attractive, maybe even less fundraising work of legislating. And, maybe that's a bit of what we need, is a little more glorification, I guess is the word, of the people who are doing, they're the node. They're
Hashing
doing
stuff
the
out in
thing
committee.
they're supposed to do. When was the last time you read a story about a member of Congress who was getting work done? You read a lot of stories about speeches. You read a lot of stories about people who are making a lot of noise. And sometimes those are the same people, but oftentimes they're not. So maybe
I think this floats back into the previous panel, and we've assigned something to the media. It's their problem. We can move on it. But it's very complex. It would be nice if coverage were a little better in that regard. I suppose it goes back to that topic of it being dry and it's not really click worthy. Well, we are headed towards ending on time. I would like to have us do a nice circle around with any closing remarks to give it a slight theme that for you guys to take or leave. It does seem to me we can have some thoughts on, your level of optimism about where we're headed, or pessimism, feel free. And I'm simplifying here. We have, are we capable of keeping up with technological change? Are we doomed to sink into rent-seeking or things getting worse in that regard? And how do things look on the individual institutional level? Don't feel obligated to stick that, but why don't we go down to the end and come back to Professor Downs, and each of you feel free to give us your closing thoughts.
Okay. Well, I'll answer a different question.
Please. No, absolutely.
Just sort of on the impact of the EPA case, because as I said, spend most of my time in industry and generally not even tech industry. But one of the things, not surprisingly, that industry thinks happened here is that it's going to be harder to regulate them. And that anytime, in fact, they get a regulation they don't like, they'll just go to court and say it's a major question, and then that'll be that. In talking this through with my frequent collaborator Blair Levin at Brookings Institution, the reality is it's not that. What's really going to happen, I think, is that much more of the regulatory process will now fall to the states. As well as to 500 district court judges and however many circuits, and the EU, by the way, which always having to pick up the slack here, and it's going to be a mess because in fact what will really happen is you'll get sort of, the Ninth Circuit will become the de facto environmental law of the country. The Second Circuit will become the de facto securities law of the country, and so on. And so, in fact, it's not that you will be less regulated, it's that you will be more regulated by many, many, many more and many more unpredictable institutions, and frankly, institutions with much less expertise and much less interest in expertise. I mean, imagine the California Public Utilities Commission. They don't care. Well,
I'm happy to call out explicitly Florida and Texas trying to
Well,
regulate social media, as
yes.
we probably hear in the next panel. Go ahead.
So I think the law that was sort of announced in the EPA case, whether intentionally or not, is the law of unintended consequences. And for people like me who advise companies, great, lots more to advise them about, and lots more confusion, always good for consultants. But as a general matter, it's not as simple as I think the initial read of the case has been so far.
We spend a month at the beach every June 15th through July 15th, and I try to do a lot of reading. I read 3 biographies of John Marshall, the first important Chief Justice of the Supreme Court. He was the 5th, but he was the first one that actually tried to institutionalize the court. The set of institutions that are represented by the US Supreme Court are hard won. They're not, for the most part, constitutional. It's a set of beliefs about expertise and legitimacy. And I worry that in addition to the erosion of respect for expertise in federal agencies and in committees, that there's going to be an erosion for respect for the unique institution of constitutional review, of the review of laws from the perspective of the Constitution that is represented by the US Supreme Court. And if that happens, then we're back in the majoritarian problems that we have largely by luck until now avoided. I think people think that the US Constitution is bulletproof, and that the chaos that we saw in the early 1790s in France can't possibly happen to the United States. I think it can. I've never been as worried as I am now. And as I said before, I'm old.
Okay, I guess final remarks. What I would say is this. Jonathan earlier really struck me when describing commentators in the media with his comment about nodes and people doing the job they're supposed to do. And I think the same principle, at least to my mind, applies to government. And so one thing that means, and I do think the court is trying to police this best it can, is that government regulators stay in their lane. And sometimes the lane is broad, right? Like we can do evolving technologies, we just have to stick to like unfairness and deception, right? So it's limited, but broad. But the other thing that requires, and I think this is critical as well, is that instead of judging, like you were talking about before, the decision on what is the immediate policy impact on the thing, which is how the headlines run and how the clicks are generated, people need to breathe, stop, whatever, and think a little bit more about, why is this the lane? And you can quibble with where the lanes ought to be, but you need to have a fair argument of why it is that way. Last week, the President of the United States did an executive order concerning abortion, and it mentioned my agency. And I'm not getting into an abortion discussion. I would humbly submit that when I was thinking about taking the job, that was not an issue that was on my dance card. Just like I almost called him Justice. Judge Posner had a bunch of issues he didn't want the courts to do, although a lot of those seem like court issues. I do think that not every part of the government is a solve to every problem. And we do better when we focus like a hawk on the thing that's actually given to us.
Larry Downs, Michael Munger, Noah Phillips, Corbin Barthold. We were also joined by Stephen Teles. This was so much fun. Thank you, gentlemen. That is all for this one. We're going to have a short break, and then we're going to talk about common carriage and social media and more. Thank you.